being the highest bidder at 36 billion, has a direct interest in the removal of Rao as an administrator appointed by this court for misconduct, which is fully set out in those two affidavits. Let me highlight, that while any bank as chargee has the right to realize its security, what it does not have a right to do is to sell the charged property at a gross value. And my Lord, being the head of the commercial division of this honorable court, is aware of the many decisions where a sale can be at such a gross value as to lead the court to conclude in fact fraud in the transaction. That is precisely the situation here. Lord, an administrator appointed by the court, or even a receiver appointed by a secured creditor, their job is not to flog the property at whatever value. They have a duty, certainly, to their secured creditor, to other creditors, secured and unsecured. They have a duty to all the creditors. And finally, they have a duty to the shareholders. Your ruling, my Lord, refer to public interest. And that public interest is definitely at play here. Because, my Lord, when you've got a vast number of farmers who have delivered their cane and have not been paid for a long time, that is a matter of public interest. So, my Lord, it is, in our submission as West Kenya, gross misconduct for Rao as a receiver administrator to have disposed of or attempted to list this project at 6 billion and rejected a bid for 36 billion. The only inference is that the difference between 6 billion and 36 billion offered by Sarai, an explanation is due from KCB, the CEO, and from Rao and from Sarai to tell those of us like West Kenya, and indeed this Rapoku, whether indeed somebody was clandestinely changing hands. And therefore, my Lord, we support fully the revocation, the removal of Rao as receiver. My Lord, initially, Rao had said the only reason for not giving this property to the highest bidder, despite the fact that the highest bidder was putting down up front 900 million as security for 6 months for the leasing of the property, was offering a bank security of 500 million, which could have been cashed if we had not performed. The only reason he had initially given was that West Kenya was going to be the dominant bid. But Lord, when that was fully disabused through our replying affidavit. Rao now comes up, having read our replying affidavit, with additional reasons. And you'll find that, my Lord, in paragraph 12 of Rao's affidavit of 11th of February, I have now had the opportunity, so that these are the reasons that he is giving, casting aspersions, that he wanted to have Mumias in order to close it down. These are afterthoughts. My Lord, the fact which we have demonstrated in our affidavits of 9th of February and 13th of February are that they are no longer zoning in the sugar farming these days. Zoning was removed. Any miller can buy sugar cane from any farmer. Okay, that is the position. When we demonstrated that Kenya has a deficit in sugar, every year we import sugar, so there is no issue. When we demonstrated that Sarai, based in Uganda, would have been the one being dominant in the East African market, which is a common market, he started creating these other excuses, which do not hold up. Because these are the misconduct, Your Lordship, you have the opportunity to go through the affidavits, including refusal to avail to this court the lease executive. When a party who has been appointed by the court does not avail the lease, what is he hiding? My Lord, I submit in conclusion that Rao should not only be removed as an administrator, that transaction set aside, but in fact his conduct disqualify him as an accountant and unsuitable for appointment as a receiver or administrator whatsoever. I thank you.
Thank you, Senior Counsel. Is there any other party who filed an affidavit in support of that application? Very well. Then we now proceed to Mr. Meto's application.